Good morning. After a long time, the Supreme Court has now uh, given a new judgment, giving a lot of guidelines, interpreting the difference between public order and law and order when Act 14, like Act Telangana Prevention of Act, was challenged before the Supreme Court. Kindly go through the judgment. Those who are practicing in SCP cases challenging detention order must strictly read the judgment para by para and note down certain para 25 wherein how grounds could be raised. This is most important. This is AR 2023 Supreme Court 4273. AR 2023 Supreme Court 4273. Amina Begum versus State of Telangana. Number 1, they say the detention order failed to differentiate between offences that create law and order situation and those that are prejudicial to public order. Offences allegedly committed by detainee were separate incidents affecting private individuals. Even in case of an offence against minor girl, police had not deemed it necessary to arrest detainee. Overall circumstances indicated that existing legal provisions for maintaining law and order were sufficient to address offences under consideration. An exceptional measure like preventive detention laws reserved for tackling emergency ought not have been invoked as a tool for enforcement of law and order. That's what they say. The next ratio. There was no direct nexus with immediate need to order detention. Order was based on extraneous consideration. Detainee had not violated conditions of bail and no application for cancel bail filed by state. Therefore, detention order is not justified. Then, preventive detention law is not punitive but preventive and precautionary, they say. This is what they said. Then they discussed about law and order and public order, deeply discussed. Then they say the detention order, regular practice of authorities treating the maximum period of detention 12 months as the standard duration is suggestive of mechanical approach. In the conferment of power to extend detention for 12 months, a discretion to make an order to operative for any period lesser than the maximum period is inherent. Whether objectives sought to be fulfilled in each case is subserved by constituting detention for a maximum period ought to bear some reflection in the order of detention. So they say why they are detaining for maximum period of 12 months. This is what they say. See para 10, kindly go through para 10. Then so many judgments were referred and all these things you can go through, and particularly para 25 they have given some 10 points how you can challenge the detention order. Kindly go through all these 10 points and prepare your detention order. See, before that it is my duty how to deal with the detention order cases. First of all, what they say, because the chronological order is being preferred for listing the SCP cases, hurriedly used to file detention cases, SCPs. See, that is not correct. First, you have to prepare appeal, the provisions therein, send representation to the approving authority and confirmed authorities and also advisory board. Then only you can file. That regulation should be there while passing, while preparing SCP. So this is the best case, and I do not want to you only mechanically follow my approach in discussing the judgment. Rather, you read the entirety of the judgment by so many citations, earlier decided cases, so that this present judgment may help you in preparing your SCP cases. Best wishes.